All right. Thank you for joining us today. My name is Christina Vessels, and I am an associate at Venable in the nonprofit organizations practice. I'm joined by Melissa Steinman, a partner in our advertising law practice. And we are very excited to talk to you for the next hour about maximizing your nonprofit's profile and your fundraising efficiency. We're going to be talking about cause-related marketing developments and strategies over the next hour. For those of you joining us for CLE credit today, we'll make sure to give you the code at the halfway mark and at the end of the presentation. And as a final sort of housekeeping matter, please feel free to send your questions in via the chat feature today. If we don't get to them during the presentation, Melissa and I will definitely try to follow up with you afterwards to answer any and all pressing questions on cause-related marketing. So without further ado, what we're going to cover today relates to what your nonprofit organization needs to know and consider when engaging in various types of fundraising activities. Certainly some of what we're going to cover today is going to be applicable to both nonprofits and the companies that support you all, but certainly our focus is more on the tax-exempt perspective for these types of fundraising campaigns. So with that, we're going to cover charitable sales promotions and CCV activity, customer donation programs, new developments in online charitable platforms and online fundraising, sweepstakes, esports, NFTs, and much, much more. So we hope that at the end of today, you'll be able to at least issue spot on all of these topics and help your organizations move forward with their development plans. All right, so to start us off, it's helpful to understand really who is watching fundraising activity in this space and where these standards for compliance come from. Obviously, state charity regulators are the ones with primary jurisdiction over charitable fundraising and cause-related marketing efforts. This really should come as no surprise to those of you watching today's presentation. You likely are aware that there are 40-some jurisdictions in the U.S. that regulate not only, how contributions are solicited for charitable organizations by charitable organizations themselves, but also how third parties fundraise for those same organizations. And for these states' solicitation law purposes, when we say, quote, charitable organization, we're not limiting the conversation to what the tax code, the federal tax rules define as charities or 501c3s. In fact, charitable solicitation laws also apply to 501c4 social welfare groups and various other types of nonprofit organizations. Importantly, charitable organizations need to be registered or exempt from registration before you begin, cause-related marketing and other fundraising efforts, at least in the states where those activities are going to take place. So this really should be, your primary focus for compliance purposes before launching into these campaigns. But with this said, individual state charity regulators are by no means the only parties that are interested with how cause-related marketing, corporate philanthropy, and all sorts of, charitable giving activities are undertaken. The FTC has jurisdiction over unfair or deceptive acts or practices affecting commerce, and they have not shied away from pursuing those who perhaps fundraise in less than scrupulous manners. And independent agencies are also taking notice of corporate fundraising efforts and, cause-related marketing, like the National Advertising Division of the BBB. We've had a big number of multi-state agency investigations come up. So it is simply put, not just charity regulators in the traditional sense that are looking at these efforts. But in all cases, whether we're talking about state charity regulators, coalitions of state charity regulators, federal agencies or others, their motivations and objectives in sort of reviewing this space are all generally the same. They're trying to protect you, your nonprofit organizations, from, folks who may want to benefit from the value of your, sort of halo effect and the sort of the goodness of your missions. And they're also attempting to protect the public from representations that unfairly, unclearly, or otherwise, improperly ask the public to support causes. So when you and your corporate partners are coming up with campaigns, whether it's the giving structure itself or the disclosures that, describe your campaign, you want to make sure you're thinking about, what the public needs to know in order to understand the full scope of your campaign and what your promotion involves. While it's generally true that the company is the one that will bear most of the responsibility for ensuring that marketing materials are clear and compliant, obviously, to the extent that those marketing materials are improperly or imprecisely drafted, this can have blowback effects for your organization. So it certainly behooves you to maintain oversight over how your names and marks are used when given the opportunity to review, marketing materials for your campaigns. So with that kind of very, very high level view of the regulatory field and, just kind of key themes to keep in mind about informing donors about what your campaign is intended to do, let's look at how these campaigns are structured and what you need to know to comply with applicable law. So when we talk about cause-related marketing or cause marketing, this is a catch-all phrase that you are not really going to find in those same charitable solicitation laws that I was just talking about. This is a catch-all phrase that's sort of been developed through industry practice, and it describes a relationship between a nonprofit organization and a for-profit company where both organizations stand to benefit, but each really has distinct roles. Typically, the company is the primary driver behind the collaboration. They get, the halo effect, the positive marketing associated with having their brand aligned with your mission. And they really should be, driving the marketing, driving the scope, driving kind of the main components of these activations. You all, as the nonprofits, by contrast, typically have a more passive role in licensing your name and marks to the company for the campaign. The main reason for this really is about maximizing the benefit that you receive from your corporate sponsor for campaigns. This stems out of, how the IRS defines advertising and the potential for incurring unrelated business income tax. We'll talk about that in a little bit, but sort of that is the underlying reason why oftentimes you have this division of labor where the company is more active and the nonprofit is more passive. But the types of, permutations for cause-related marketing really run the gamut. You have everything from very straightforward, simple, easy to execute corporate supporter statements, kind of like what we see here, where, a company simply wants to let its consumer base know that it supports your charitable organization. It's not linked to purchases. The donation has already happened. The company is simply letting the public know that it has done good. And what you don't see here is actually the logo of the charity was sort of off the image of this dry cleaner hang tag. But in any case, that's sort of your most simple type of cause-related marketing and corporate sponsorship arrangement. And obviously it works up to more regulated types of fundraising ventures that we're going to talk about, like, CCV promotions, sweepstakes, and the like. But for all of these campaigns, you're generally thinking about compliance, in sort of three main buckets. Do you have pre-promotion compliance obligations or obligations like contractings or filings? Are your disclosures or marketing materials clear? And finally, what, if anything, needs to happen after a campaign has closed? That sort of is the general theme and framework for all sorts of cause-related marketing campaigns. But by and large, charitable sales promotions conducted by commercial co-ventures, or CCVs for short, I think continue to be the perennial favorite and the perennial leader in terms of cause-related marketing. A company acts as a CCV when they advertise that the purchase or use of a good or service will benefit a charitable organization. So anytime you are linking that consumer paid activity, typically paid, I should say, buy our product and we'll donate X to charity, or something, use our credit card and we'll donate Y to charity, you're generally in the realm of charitable sales promotions. As I mentioned, what does it take to be compliant from a charitable sales promotion perspective? It's the same framework: pre-promotion, during promotion compliance, and post-promotion compliance. So before your campaign launches, you want to make sure you have an agreement in place that meets the various statutory requirements for your campaign. State law typically requires certain terms to be included in your agreement. For your nonprofit, your pre-promotion compliance can sort of be viewed in two lenses. First, as an initial matter, are you registered to solicit in all of the states where your campaign will take place? This is separate from where the CCV eventually needs to file, but it's intertwined with that activity, because the CCV obviously cannot file their pre-promotion filings if your nonprofit is not registered to solicit in the state where the campaign will take place. But as the nonprofit, you would submit pre-promotion filings in just a handful of states if your campaign is nationwide. And so, at least from your perspective, the pre-promotion compliance is fairly straightforward, and oftentimes it's limited to just reviewing and executing the contract and submitting copies of that contract in Arkansas, Connecticut, New Hampshire, New Jersey, and Utah. After the promotion, you want to make sure that you're receiving an accounting from the corporate sponsor, together with, receipt of the payment, sort of that gives you enough information to ensure that the terms of the promotion were, accurately complied with. And this also enables you to file your charity's closing report for the campaign in New Jersey. So at the end of the day, the company is very likely to send this information on to you anyway, because they'll need to collect it for purposes of their closing reports, and they'll need your signatures on those reports. So you should be getting the information. But if you don't, you want to make sure that you are following up to request those details. But in between, while the promotion is ongoing, this is really where you want to give a second set of eyes to the commercial co-ventures efforts. They likely will, or at least should, ask your nonprofit to review proposed uses of your name and marks. And when reviewing those materials, you can use this as an opportunity to make sure that the public representations for the campaign align with your understanding of what the parameters of the promotion are, and any other standards you need your partner to adhere to. For example, if your nonprofit is accredited by the BBB Wise Giving Alliance, you're oftentimes going to be looking to make sure that the partner's disclosures satisfy standard 19. So while state law is actually pretty Spartan in terms of what it requires for CCV campaign disclosures, industry practice, best practices and the like have generally coalesced around, the details that you include here. And obviously, not all of these details are included every single time because you may be space limited. Maybe you're promoting something on social media and you have character limitations or what have you. The key is really making sure that, all of these material terms at least appear in full to the consumer or to the prospective donor prior to the point of sale. So at the outset, I noted that unrelated business income tax or UBIT issues could arise. And while we're talking about marketing and disclosures, this is really, I guess, a good time to close the loop on that UBIT issue, since this often arises in the CCV context, although it certainly can come up in other types of promotional endeavors as well. But the gist is that your nonprofit should consider how certain deliverables given to the sponsor might affect the value of the sponsor's contribution. In really broad strokes, contributions or income earned in ways related to a nonprofit's tax-exempt mission are not taxed, but money received for purposes that are, quote, unrelated to your exempt purposes may be taxed. And that's the UBIT, that's unrelated business income tax. If a nonprofit promotes or, let's say, endorses a sponsor's products or services, or otherwise induces the purchase or use of a sponsor's product, rather than just simply thanking the sponsor for their support, this can cause the income the nonprofit receives to be subject to UBIT because advertising is seen as a substantial return benefit. This may be so even though the promotion of the product or the qualitative statements in support of the sponsor ultimately benefit your nonprofit too, right? Encouraging sales of products in a CCV campaign obviously benefits your organization if you're receiving a portion of those sales. But the fact that your nonprofit stands to benefit from increased sales doesn't negate the potential for incurring tax on income if you advertise for the sponsor. Obviously, incurring this tax, if at all, would diminish the value of the company's support, and the nonprofit can really run into issues if you generate too much UBIT. But I want to be clear that UBIT itself is not illegal. It's not even, it's not frowned upon. This can become problematic if you incur too much UBIT. But all of this is to say that simply you should be aware of the issue if a corporate sponsor asks you to produce certain deliverables in exchange for a contribution or to advance a promotion. You want to be sure you're at least considering how those return services or return benefits might affect the value of the corporate sponsor's support. So whether your nonprofit elects to proceed with advertising a cause marketing campaign or not is really, that's entirely your decision. But understanding the bounds of what's considered taxable advertising versus what is not taxable, what is a permissible use and acknowledgement of the corporate sponsor's name and logo, knowing the parameters here is really going to be critical for your organization so that you at least don't inadvertently veer into promotional efforts if that wasn't your intent. So you'll want to kind of keep these items in mind as you're going through and collaborating with the corporate sponsor, particularly in the contract drafting phase, so that everybody is clear in terms of what the obligations of the parties will be. All right, we probably could spend an hour on UBIT issues alone, and there really are, countless videos on our website about this topic. So I know that was brief, but we're going to bring it back to cause-related marketing and specifically now customer donation programs. These types of campaigns where customers are given the chance or opportunity to add money to their purchases have been among the easier types of campaigns to execute. They are entirely elective. The structure is often something like a roundup campaign or a set the amount that you'd like to add to your transaction, something like that. And usually this type of arrangement follows the general rules for charitable trustees. The company needs to document how the funds will be raised, how they'll be transferred to your nonprofit organization, when, things like that. And by and large, they're fairly easy to execute. I would say the biggest issue here historically has been ensuring that 100% of customers' donations are transferred to the charity. This is really critical because in this way, the company is acting simply as a volunteer. They are acting as a limited agent in facilitating solicitations for you, but they are not deriving compensation or other consideration in exchange for fundraising on your behalf. Because if they were being compensated to fundraise for you, this would really change the nature of the company's activities into what is typically seen as professional fundraising. Those who are paid to solicit for a nonprofit or who are, otherwise, take custody or retain control of funds raised for charity. You really don't want to inadvertently veer into this realm because the compliance obligations for professional fundraisers are significant. And so this is, that is something that you absolutely don't want to haphazardly enter into. So when conducting a customer donation program, particularly, in-store, in-person events, the biggest takeaway here is to ensure that 100% of the customer's donations are timely transferred to your nonprofit organization. But very importantly, the rules affecting customer donation programs and really all sorts of fundraising structures that occur online, including the ones that Melissa's going to talk about in a few minutes, this is all sort of at present in flux. Starting January 1st of next year, customer donation programs that are conducted online and all sorts of online fundraising efforts where a person, permits or facilitates fundraising online are going to be regulated in California. Last fall, the Governor Newsom signed into law Assembly Bill 488, which amended the state's charitable solicitation law. Proposed regulations on implementing the law were passed or published in late May, and we just had the comment period and hearing on the proposed regulations close out last week. So I'm expecting that, in the very near future, we're all going to have definitive rules on how this new law is going to be implemented. We don't have them yet, but, we certainly can give you our take on where we think the law is going, and we'll be sure to follow it up with written guidelines for you all. But as I mentioned, the key takeaway is that the new bill will regulate charitable fundraising platforms that engage in, what are seen as commercial co-venturing, peer-to-peer fundraising, commercial fundraising, all sorts of activities. And the companies that engage in these activities are going to have fairly substantial new compliance obligations. But the law will also regulate platform charities that, assist these platforms with their fundraising efforts. and impose sort of new requirements for the ultimate beneficiaries. So anything from, you know, new contracts formats to new registration forms, your organizations may start to see a shift when it comes to online giving efforts because of this new California rule. So although the regulations and parameters with complying with the new law aren't yet final, we are starting to get a sense of some of the key components that the platforms themselves are going to need to comply with. As I mentioned, most of these are going to affect the company and not your nonprofit as the beneficiary. But I guess I'll call out, a few of the key items that sort of tangentially talk to what your benefiting nonprofit, might need to do or to have some say in. The platform will need to provide, in some cases, tax donation receipts to donors within a very quick turnaround time. So that'll be a conversation you'll want to have with your partners before going live with these campaigns. They'll need to make sure to transfer funds to you within 15 days, give or take, depending on how the platform is categorized. And I suppose there are also going to be, as I mentioned, contractual matters that need to be handled up front. But if you find that you actually see your nonprofit listed on an online giving platform and you were not presented with a contract, it may be that the platform was able to take one of the options for not needing to get your written consent, but that in turn will give you opt-out rights. So, you'll just want to be kind of monitoring how your organization is appearing online and really, taking control of, whether or not you are comfortable with certain online platforms listing your nonprofit organization. So I guess there's, as I mentioned, it's really the charitable fundraising platforms that are going to have the bulk of the new compliance obligations, but platform charities will also be regulated under the new law. This is kind of like donor advised funds and other really large charitable organizations who facilitate fundraising on these platforms by, making grants to recommended beneficiaries like yourselves through the fundraising efforts. And I suspect, though, that most of you watching today's presentation, as I mentioned, are going to be viewed simply as recipient charities. And your obligations, at least with the state, are going to be fairly minimal. Again, you'll want to determine whether or not certain activities will force your organization to register with the California Registry of Charitable Trusts. If you're presented with agreements by the charitable fundraising platform, you'll want to review those for compliance with the law. And so sort of, again, is up to you all to become sort of familiar with the rules once they are published. And you'll want to, have a handle on how is donor information shared, what other, information will be passed on to your nonprofit organization so that you can take the online fundraising activities of the sponsor and potentially build out your own development, objectives. I guess finally, from a practical perspective, one common theme that we heard during last week's hearing was that companies who will be subject to the law were requesting more time to implement the changes that are going to be needed to meet the new standards of the law. This may mean that there could be a lull in fundraising efforts in this space come the new year if companies haven't been afforded more time to comply with the law and feel like they're not in a position to meet the technical requirements for, how quickly donations need to be transferred or, issuing tax donation receipts and the like. So it sort of remains to be seen. Once the final regulations are posted, we'll have a better handle on that, but it's certainly something to keep an eye on as online fundraising efforts affected by AB 488 may slow down sort of towards the end of the year and into the new year. All right, so for those of you watching today's presentation for CLE credit, this is a good moment to, I guess, share for the first time the CLE code. It is Fundraising 2022. Again, today's CLE code is Fundraising 2022. And with that, I guess I'll leave you with stay tuned for more insights from us on the final regulations once they're posted, because these are going to affect cryptocurrency donations, charitable sweepstakes, and all of the fun things that Melissa Steinman is about to talk to you all about. So with that, I'll turn it over to you, Melissa. Melissa, I think you are still on mute.
So embarrassing. We should be up to date on that by now, right? In any case, we're going to spend the next 25 minutes or so, give or take, maybe 20, and give you some time for questions to talk about some of the promotional efforts like charitable raffles, sweepstakes, esports, NFTs, and some of the more up-to-date uses that we're seeing in terms of charitable efforts and how they may be regulated, what's working particularly well, that sort of thing. So to start with sort of the basic structure, when we talk about charitable raffles, sweepstakes, and promotions, what we're talking about here is particularly interesting when it comes to charities and nonprofits, because you've got this overlap of a structure, a legal structure that's already really difficult to comply with, the lottery and gambling laws, and then the charitable solicitation laws. So whenever you're analyzing a sweepstakes or a contest or a raffle, you first got to look at whether you're complying with, or you may be violating, the lottery laws, which are prohibited under federal law and all 50 states. And those laws have three elements, or if an illegal lottery has three elements, which is the award of a prize by chance, where participants must submit consideration to enter. And consideration is a legal term, but it is basically just about 100% overlap with the version of consideration that all we lawyers learned about in contracts class, in terms of the fact that it can be a benefit to the sponsor or a detriment to the entrant. However, that's the general concept, and under some state laws, it's defined that way, but then each state has its own definition. So there's a group of states that strictly define consideration as money, a purchase or payment. And in those cases, as long as you're not asking people to buy something or pay or donate in order to enter, you're fine. Whereas in other states, even some substantial commitment of time, taking a survey, asking them to do something that involves some kind of effort, going to a conference, which often involves a payment anyway, going to a conference booth. And so there's this whole analysis once you're in these non-monetary consideration states as to whether there's enough consideration that may violate that state's law. One thing I get a question about a lot, by the way, is, what about a survey? Will that violate? Generally, a very quick survey is okay, a few questions, a few minutes, but a lengthy one is not going to be okay, just to knock that one out. Anyway, you do this analysis. then, say you come up with your answer. In any case, you look at whether your promotion is going to fall into one of several types of giveaways, shall we say. The first one is that nonprofits particularly are allowed to run raffles under state law exceptions that say that basically if you meet the specific state's requirements, which may encompass registration, you may have to have a physical presence in that state. There may be limitations on how much you may give away in a specific raffle or in a given year. You may have to be a registered charity in addition to registering for the particular raffle, that sort of thing. But if you meet those requirements, you can actually require a purchase or donation in order to enter. So we have those raffle laws. Unfortunately, those requirements are so onerous that it makes it nearly impossible, if not totally impossible, to run a national online raffle. I'm noting California, for instance, prohibits online advertising or involvement of anybody outside of the nonprofit in running this type of or online entry rather than advertising and involvement of anybody outside of the nonprofit, which is actually a pretty common requirement. So we're setting aside raffles. Then you look at whether you can run a sweepstakes, which essentially is giving away a prize using chance, like random draw or something like that, where consideration is not required. With the sweepstakes, you can give away, but either you can't require any kind of consideration, or a lot of people use this sort of get out of jail free card, which is offering a free alternative method of entry. Typically, we think a lot of us think about the 3x5 card that you're asked to send in a lot of these giveaways. It can also be online, filling out a form. What's important is that the free entrants must be offered equal dignity. They must have an equal opportunity to enter, same number of entries. It can't be unduly hard to enter, that sort of thing. It must be advertised clearly and conspicuously, which is something we've seen a lot of companies get into trouble about, both in class actions and in regulatory enforcement cases where they've had the free alternative method of entry, but they've hid it away and not included it in all the advertising for the promotion. And there must be obviously the equal opportunity to win the same prize. So those are sweepstakes. And then there's also contests where you've eliminated you've eliminated chance. You're picking the winner using some sort of skill, whether it's a competition for who's the best, a golf competition or something like that, sporting competition, or some sort of judged competition where you have, judges with expertise picking according to some sort of criteria that are clear to all of the entrants. In any case, what we're seeing increasingly is this sort of hybrid of the charitable sweepstakes. And we'll talk about those in the next slide. And are you doing switching this time as well? So like I said, rising popularity of charitable sweepstakes. We're seeing these offered by by nonprofits working with commercial entities. They're actually something that is not necessarily clearly addressed by every state under their laws. The clearest law that we've got is under Florida, which has an explicit exception to the lottery laws for nonprofit sweepstakes. One thing to understand is that typically when you have a sweepstakes that's legal, or any type of promotion that's legal, it's under this exception to that prohibition under the lottery laws, which is a form of gambling. So generally, you either have case law or an explicit statute like Florida that permits these sweepstakes and raffles and explains precisely what you have to disclose in the rules, which is the other tricky part, is getting your rules correct, making sure that you disclose the material terms that are required under those sweepstakes laws, that sort of thing. The other thing about these charitable sweepstakes is that the for-profit is often required to register under professional fundraiser laws, which is an area where the California Attorney General has gotten involved lately in several settlements involving some of these companies like Prizio and Charity Buzz, where they failed to properly maintain their registrations as professional fundraisers. So that was an interesting issue that came up in California recently. And one of the things that's addressed by these new laws and the legislative process that was gone through. In any case, what's important to understand is these charitable sweepstakes are different from raffles. They're different from your standard commercial co-venture campaign. They're different from auctions. It's important to understand that you are meeting the requirements in terms of the sweepstakes laws, making sure that there's no required purchaser payment. There's a free alternative method of entry that is clearly and conspicuously disclosed, and that whoever you're working with is properly registered under the professional fundraiser laws. That's sort of all the T's are crossed and the I's are dotted in terms of the disclosures before you move forward there, because you don't want to be in the middle of anything that may not be working, particularly in terms of those disclosures that are compliant with the sweepstakes laws. Next slide. And so these are the types of things that you want to make sure are disclosed. I mentioned the no donation required method of entry. You also want to make sure that the agreement that you have with the company that is running the charitable sweepstakes, that you have an agreement where you provide consent to use your name and marks and give explicit approval over whatever uses that you're giving. Again, we've talked about this arrangement for, transfer of donations, that there's an accounting as well to make sure it's very clear. There's a class action right now against one of these companies over proper disclosure of what portion of the donations is going to the charity. So you want to make sure it's being disclosed both on the website and to you, what portion is going to the charity versus what portion is going to the company that's running the sweepstakes. Additionally, you should make sure that everybody is in good standing in terms of their registrations. And then make sure that the company is following state law. And we recommend also making sure that the company is following the PayPal Giving Fund settlement frameworks for disclosures, which essentially says that it should be making an unavoidable and prominent disclosure whether fees are charged on donations, if there's an intermediary charity being used to process donations and then distribute them to any charities involved, that's disclosed, names, contact information, whether the donations are tax deductible, information like that is being disclosed. And by the way, typically they won't be tax deductible. Next slide. So another interesting type of fundraiser we're seeing a lot more now are these esports fundraisers. The type of thing where perhaps on Twitch or a streaming platform, or as part of tournaments that are being run, you see the sponsor or the player setting a fundraising goal, naming a charity, and then stating that they will donate part of either the donor's registration fee, the player's registration fee, or, that sort of thing. And some of these it's important to understand what the sort of value proposition. Sorry, I got a little cold there. It's important to understand what the value proposition to you as the charity is, and then also analyze it just like you would any other CCV or that sort of thing. So, you can see with the top proposal, when you register to play in this tournament, the sponsor will donate 25% of your registration fee to ABC charity. That's more of a CCV proposition. Whereas the second one is that's not necessarily the case. And there may be ways to structure these types of arrangements in a way that you may not have to worry about CCV compliance or some of the complexities, in still being able to participate in what's, sort of a very hot area that reaches out to young people and is of interest to young people. When we talk about esports, these are these video game competitions. They may be online or they may be live, but generally it's a legal contest where the prizes are awarded on the basis of skill. So while there is a payment involved by the players, there is not the same kind of lottery concern that you might have in, a sweepstakes. It's not the same analysis, basically. Some of these, there are a few states that have specific esports laws. The other thing is that there are more and more we're seeing sports betting laws, and it's important to look at the proposal if you're getting some of these, particularly with online, and make sure that you understand the distinction between esports and sports betting, simply because sports betting right now is a more highly regulated, a little touchier, and you're going to have to worry about, making sure that you're not getting involved in gambling, or at least that you understand what you're getting involved with when you associate the charity's name with it and you're okay with it. Okay, next slide. NFTs, another sort of hot topic right now. I think it's in the news regularly. None of us understand it that well, but it's definitely interesting. When we talk about NFTs, we're talking about a non-fungible token that serves as proof of ownership of a unique digital asset, as opposed to cryptocurrency, which is not unique. Both of them, the purchase and sale happens through a blockchain. With an NFT, essentially it's occurring, the exchange is occurring through a smart contract that includes an IP license. And the contract includes things like details on the payment amount, what IP rights are included. It's typically not all. It's just, essentially the right to a limited license. Then the transfer, the costs, accounting of sales. If it's sold again, then, very limited rights are passed on. But when you are participating in any kind of NFT transaction as part of a charitable offer, you want to make sure, again, like most of these promotions we're talking about, that disclosures are very clear, that any fees that are being deducted are being disclosed. So if there are fees associated with opening the wallet that will be necessary to receive the NFT that is purchased, that should be disclosed in addition to any donation or any other fees that are associated with the transaction. And you want to make sure that that's happening in addition to how your IP and trademarks are being used, how your charity name or your contact information are being disclosed, and that sort of thing. Often, these types of promotions involving NFTs are structured as a charitable auction. But they could be considered a charitable promotion and raise CCV compliance considerations as well. So we have an example here where Charmin offered an NFT and let consumers bid on this specific piece of digital art, where the proceeds were then donated to Direct Relief as the charity, with just the highest bidder winning. That was a simple auction setup. Everybody else got their bid back. So that was structured. It's important to keep in mind that with charitable auctions, there are state laws that can be involved, like with any auction, and so you need to keep that in compliance. Often it's a good idea to use an entity that specializes of fundraising or otherwise in auctions and setting this up. Next slide. And I have some of the other considerations here. We talked about intellectual property. You want to make sure that all licenses, all copyright terms and reproduction rights are clear in that smart contract we're talking about. When you have the terms and conditions for the specific NFT promotion, that has to be clear at the outset, both as to what fees are involved, how the promotion will work, what is being offered, including that limited right. In addition, when you run a sweepstakes involving an NFT, there can be special concerns because obviously the fees and the requirement to purchase an NFT could be considerations. So there have been promotions that have asked sort of associated a sweepstakes entry specifically with the purchase of an NFT, saying you'll get an entry when you buy this NFT. That is consideration. So you have to offer a free alternative method of entry that is clearly and conspicuously disclosed. When the NFT is the prize, there's an interesting issue there because upon first purchase, an NFT often does not have a set value. Its value is set essentially when it goes to the market, and people determine what it's worth in the secondary market. So the question is, one of the rules under state law is generally that you must disclose prize value in your sweepstakes terms, and how do you do that? That's one thing. And there are issues with regard to chance as well, can be issues, but aren't always. Coming to the end, I believe. Next slide. Just some general pointers. You want to make sure when you are the charity and you are involved in a sweepstakes that you're monitoring what third parties are doing, what promises they're making when they are making, an offer involving your name, how they're using your brand, that they're staying within sort of the contracted terms that you've agreed to, and maintain the authority to review any marketing assets featuring your name and your marks. Additionally, this can involve increasingly influencers and the use of influencers that the brand may sort of turf out the offers that they're coming up with too. So, as part of the agreement you enter into with, the brands that are running these offers, you may want to consider, maintaining at least the right to review, if not doing so. Next slide. One of these things, just a specific, is remember that compliance with the FTC's endorsements rule, which is really a hot topic right now, requires disclosure of the receipt of consideration whenever, say, an influencer is asked, is given something in order to promote or the like. And while this is not, the FTC does not expressly regulate most of the time charities, it is an expectation that when there is even a charitable promotion and an influencer gets involved, or some other, in a sweepstakes, you even have to, disclose that you are getting a sweepstakes entry. So like, say you're participating in a sweepstakes, you're getting the entry in order to win a prize. That is consideration according to the FTC. So you're supposed to be disclosing if you are asked to post online, #sweepstakes. So, I'm entering to win $1,000 gift card. That's consideration. I'm asked to post online as an entry. I put in #contest. Next slide. Finally, mobile giving is regulated by the Telephone Consumer Protection Act. So if you want to collect as part of your campaign mobile phone numbers, you have to get express prior written consent. The CTIA provides guidelines for mobile giving. And so those are very helpful. They also offer short codes that you can use to do this. So it's helpful to go to those in order to get some guidelines on how to do it. This is an incredibly strict set of provisions and only getting stricter. It's very actively enforced. So this is something that you want to pay attention to. Next slide. Finally, think about privacy. What information are you getting as the result of these promotions? How are you going to use it? Make sure your agreements cover that with the brands to the extent you're participating with brands. In particular, the new California Consumer Privacy Act, which does not explicitly apply to nonprofits, will apply to the companies with which you're working. And so your supporters' expectations will apply that, you are complying with much the same guidelines when you work with them. So it's important to, if your members are asking you, I want my information deleted, that sort of thing, you need to be ready to do that. And you should be understanding these requirements as you work with the brands as well. Next slide. So final considerations. Christina, do you want to take over and do the wrap up?
Sure. So I guess, first and foremost, thanks for joining us today. We hope that, what we've shared with you has been helpful in issue spotting for these types of promotions and fundraising vehicles as you collaborate with your corporate sponsors. I think overwhelmingly the takeaways are, in each of these campaigns, do you as the nonprofit organization understand, and have you contracted with the other party to understand who has custody and control of funds? Will the company be retaining any amount of the funds raised, or will an influencer be paid or retain any amount of donations raised? Understanding the mechanics of how donations flow from the public to the corporate sponsor, potentially through an intermediary charity and onto your organization really is going to be critical too. And then how your organization either promotes a particular campaign or otherwise thanks your corporate supporters. These are all overarching considerations for each of these types of campaigns that you'll want to think about. But in terms of the specifics, we hope that you found the materials presented here helpful, and you'll be able to refer back to them. We did see some questions come in, and we will be reaching back out to folks to answer those since we did not have time today. As a final parting note, for those of you, again, watching for CLE credit, today's code is Fundraising 2022. So again, thank you for joining us today. Melissa and I were really glad to be able to speak on the topic, and we look forward to at least on the California AB 488 front, following up with some articles soon on the scope of the final regulations. So we'll be seeing you. Thanks for joining. Bye-bye.
Thanks so much.